His Excellency President Zuma is a very resilient man. He comes here to fulfill the legal duty of observing the law and being exemplary in terms of respecting the laws of the country. But every time he comes here with a little glimmer of hope that eventually there'll be justice, and he always gets disappointed all the time.
You know, I cannot even count the newspaper articles or so-called expert commentators who say that every time Mr. Zuma is treated differently to other people, it is to show that we're all equal before the law. Well, that's a joke, because it can be that we show that we're equal before the law by treating a particular individual differently from all the other people. That's just wrong. So, if we are equal before the law, let's be equal before the law. Let's not have a Zuma law. Let's not have some laws that are uniquely reserved for him, because that flies in the face of Section 9(1) of the Constitution, which says we are all equal before the law.
In our submission, the interests of justice require the contrary, namely that the matter now proceed to trial on the accused's pleas of not guilty. The fifth reason why we submit this application should be refused is that in our submission, the purpose of Section 390 must be to permit the SCA to consider and to provide the answer to a question of law which it has not previously decided. In other words, if a High Court is to grapple with a new question of law, new in the sense that the SCA has not decided it, and the answer to that question will or may have a decisive bearing on the shape and further conduct of a criminal trial, then a court may legitimately, under this provision, refer that question for the consideration of the Supreme Court of Appeal, with the necessary consequence that the trial would be held in abeyance in the meantime. All of that doesn't apply where, as has happened here, the SCA has already decided the question of law. It has already decided the proper interpretation of Section 106(1)(h). For all of these reasons, then, the State asks that all of the applications by the first accused be dismissed.
The application for leave to appeal is adjourned to the 16th of February, when I again hope to be in a position to give judgment. You can take it that I will deliver a short judgment on that day. If I, during the course of preparation, run into difficulties, then I shall advise the parties if the matter is going to be adjourned on that day. But hopefully, as the last time, I hope to be in a position to present at least a summarized judgment, and then with the full written judgment to be handed down at the same time.